Income taxation of joint revocable trusts. That's the subject of today's ACTEC Trust and Estate Talk.
Welcome to ACTEC Trust and Estate Talk from the American College of Trust and Estate Counsel, a professional society of peer-elected trust and estate lawyers in the United States and around the globe. This series offers professionals best practice advice, insights, and commentary on subjects that affect our profession and clients. And now, our ACTEC Fellow host with today's topic.
This is Doug Stanley, ACTEC Fellow from St. Louis, Missouri. Joint revocable trusts have simplified income taxation in many respects while both grantors are living. When one spouse dies, complexity arises unless the surviving spouse can revoke both halves of the revocable trust. ACTEC Fellow Steve Gorin, also from St. Louis, will tell us more. Welcome, Steve.
Thank you very much, Doug. It's a pleasure to be here. So we'll talk about joint revocable trusts. So, of course, as you know, a revocable trust is a trust that a person can change, amend, revoke, totally control however they want. And it's just an estate planning substitute for a will so that you can avoid probate. So in most states, we're used to having just each spouse in the marriage has his or her own revocable trust. And that simplifies things. But a lot of married couples are uncomfortable with dividing up their assets and saying, well, this is the first spouse's, this is the second spouse's, etc. And so a lot of spouses like to keep them in joint names. And in some states, like our home state of Missouri, you can have special asset protection if you have the spouses keep their assets in both names in a revocable trust. And a lot of other states that you can hold assets as community property. And that's typically the ones that used to be owned by Spain or Mexico that now became part of the U.S. many years ago. There's a variety of other states that are not in that area who've adopted this community property status. And in a community property state, basically each spouse owns the property half and half. But you usually will set these up as a revocable trust where each spouse is the deemed owner of half of it. So a revocable trust is a grantor trust, meaning that you can use the grantor's social security number, the grantor being the person who put the assets into the trust. So when you have a joint revocable trust, regulations allow you to use either spouse's social security number as long as you're filing a joint tax return. And joint tax returns do tend to save income taxes. That's what most spouses do. So you may have people with a community property joint revocable trust, or you may have people in a common law state that decide that they just want to pull their assets in one joint revocable trust just to try to keep things all together and loving family-like. And again, if they just file the joint returns, they can use their own social security numbers, and they go along merrily without any income tax complications whatsoever. However, when one spouse dies, and if this property was owned half and half, so what happens is you have one half of the property kind of belonged to the decedent, and even though it was in a revocable trust, it was really the decedent's half that the decedent was considered to have put into that trust. And then you have the other half that the surviving spouse tends to hold. They just keep it as their own revocable trust. So you have these two halves now, and the grantor trust rules will treat a person as the deemed owner of the trust only if they put the money into the trust themselves. And so what will happen is the surviving spouse, when they can continue to revoke their half, they get to continue to use their social security number for that half of the trust. But the decedent's half has the decedent as the grantor. And it doesn't matter what kind of grantor trust powers are in there. The decedent is no longer living, so the decedent is not a taxpayer anymore. It's the decedent's estate who could be the taxpayer, or in this case, when you have a revocable trust, that one half of the trust is no longer revocable. And so for that one half, you have an irrevocable trust. And so for an irrevocable trust, you've got to stop having grantor trust treatment. So in many cases, when you have a community property trust or this joint revocable trust, and you have the decedent died, so post-mortem, you have one half is a non-grantor trust that has to pay its own taxes, file its own tax return. The other half is a grantor trust. Now, typically what you'll do for that is you'll get one tax ID that will receive all the 1099s and other tax reporting documents, and then the trust will file a single trust income tax return. And on that trust income tax return, it would show that one half is deemed owned by the surviving spouse and reported solely to that surviving spouse. And then the other half just uses normal trust income taxation, which is beyond the scope of this podcast. Now, if you want to try to keep things simpler for the surviving spouse, and the surviving spouse doesn't want to have to file a separate, trust income tax return that has this 50-50 split going on with it, you could have an estate plan where the surviving spouse has the right to pull out the entire trust, not just the half the surviving spouse is deemed to have contributed, but also the decedent's one half. So in that case, you have two separate sets of rules that are applying. The surviving spouse's half is taxed to the surviving spouse because the surviving spouse is the grantor and has the right to revoke that part. The half that came from the decedent, because the surviving spouse has the unlimited right to withdraw that amount, the surviving spouse is treated as the owner under a special rule. So I'm going to just throw a few code sections for those who really like those. So Code Section 671 is what makes the grantor be the deemed owner. Code Section 672 to 677 talk about different rules and when what powers the grantor has to have, or what other types of features have to have in the trust for the grantor to be the deemed owner. So 672 to 677 are basically the powers that can cause grantor trust status to occur, but 671 is what causes the grantor to be taxed when those 673 to 677 powers exist. There's another provision, Code Section 678, that says if the grantor is not the deemed owner of the trust and the beneficiary has the right to withdraw what's in the trust, then the beneficiary becomes the deemed owner. And you're not looking to 671 or 673 to 677, you're looking to 678 itself. So if you have the surviving spouse able to withdraw the entire half as a beneficiary through this joint revocable trust mechanism, where the joint revocable trust survives until the surviving spouse's death, then you can have both halves of it be a tax just like it was a revocable trust of the surviving spouse, and use the surviving spouse's Social Security number. Now, there are some people who are a little bit confused by these rules. They don't understand that you have to have 671 apply normally to have a grantor be the deemed owner. And there's some people who say that when the first spouse dies and the surviving spouse has a bunch of powers, but the surviving spouse does not have the right to withdraw it, they try to say that that is all taxed to the surviving spouse. And they are dead wrong about that. And so don't rely on any of that. The surviving spouse has to have the right to withdraw both halves of the trust in order to be able to use the surviving spouse's Social Security number. So this kind of an arrangement is not good for estate tax planning, but it can be a terrific solution for people who have estates where the combined estate is going to be much less than the federal and any state estate tax exemptions. So I hope you found this helpful and look forward to future contact with you. Thank you.
Thank you, Steve, for providing your expertise.
Thank you for listening to this episode of ACTEC Trust and Estate Talk, the podcast series about wealth planning matters from the American College of Trust and Estate Counsel. To find an ACTEC lawyer near you, visit actec.org. Please subscribe to this series and leave us a rating or a review. Follow us on Facebook and Twitter at ACTEC Talk.